welcome you to the talk by Dr. Prachi Pandey on patentability of inventions, case studies, and claim drafting. This event is being organized by IPR cell of BML Munjal University and Atal Community Incubation Center, in short ACIC BMU Foundation. Before we start today's event, I would like to give a brief introduction about today's speaker, Dr. Prachi Pandey. He is currently working as Associate Professor and Deputy Director, Krishna Center for Startup and Entrepreneurship at Drs. Kiran and Pallavi Patel Global University, Vadodara. Dr. Prachi Pandey has 14 years of experience in academics and research, and she has her PhD in pharmacy. And in addition to that, she also have a postgraduate diploma in patent laws from National Academy of Legal Sciences and Research, Hyderabad. And she is a registered patent agent with the Indian Patent Office. She received many awards, accolades, and is widely recognized for her work in the area of patents. Her research received funding from governments of India and Gujarat, and she is a very good researcher who published 24 research papers and authored 5 chapters. She has given many lectures, 27 lectures and training sessions on patent, trademarks, and copyrights at various events organized by the Government of India and at various universities. Now I welcome Dr. Prachi Pandey for this event, and I would kindly request her to give her talk. Thank you, ma'am, Dr. Prachi Pandey.
Dr. Prachi, namaskar. We cannot hear you. You are on mute, Dr. Prachi.
Is it audible, sir?
Yes, yes. Now it is audible. Please start your session.
Can I start? Fine. I'm sharing my screen, first of all. Please let me know whenever the screen is visible and it is in full screen mode. Sir, is it visible?
Not. Yeah. Now we can see.
Okay, fine. So, a very warm greetings.
Yeah, you can keep it in the full screen, ma'am. Ma'am, actually, you can put it in this. You can. Yeah. Okay. You can put it in the full screen. The presentation mode.
Fine.
Okay.
Is it in presentation mode now?
Yes.
Is it fine? Okay. Okay, so warm greetings to all the organizers of BML Munjal University. Yeah, it's a great opportunity to speak to the innovators who are working hard for some innovations and trying to protect their innovations by intellectual property rights. Thank you very much, sir, to Dr. Amarnath, sir, Dr. Amiya Das for organizing such events for the innovators. So let's start. Whenever we do any innovations, it's very important to know whether it is patentable or not. Because once we are confirming that our innovations have the qualifying for the patentability criteria, as well as they are not falling under any of the criteria which are non-patentable inventions, it is very comfortable to get it granted. So for a smooth crossing of the pathway from filing to prosecution, it is important that we consider the patentability aspects as well as to always avoid anything which can make us fall in the non-patentability criteria. So we will see today what are the basic benefits that Indian government has given. This I always repeat for innovators because this is a very encouraging slide that I have received from the Indian government, like gadgets and informations. So 80% rebate on the filing fees. Startups and individuals, now organizations also, they pay 80% less as compared to the companies. So we need to pay just 1,600. Fee for request for early publication. If we wish to publish it after filing within 1 week or 15 days. We have to fill the form 9, and just by paying a fee of 2,500. For companies, it is very high. If we wish to go for expedited examination process, we can complete our examination within 105 days by just paying a fee of 8,000 and by filling the form 18A. In a normal examination process, usually we file the form 18 and we have to pay rupees 4,000. So it is double amount, but it is very less as compared to companies who are paying about 60,000 for an expedited examination. Along with that, we have a facility of 90% refund for the application withdrawals. So suppose if an applicant can think that their application is not so worth to be patented, or somewhere during his research he found some drawbacks, or he found some data are not actually up to the mark, they can withdraw their patent applications, and there is a 90% refund of application fee upon the withdrawals. And also there is tax exemption for 3 years. This is not a patent like benefit, but whenever any company startup firm is registered by an innovator, then tax is exempted for the first 3 years. That is a great benefit actually for an individual or student registering a startup. Now comes the patentability criteria. This is very important to be studied. I just request all the innovators that they can fit their project, their innovations in the criteria that we are discussing today, and also think of that we shouldn't do anything which is making us to fall in the non-patentable inventions. So as you all know, we have to cross the nonce test. Nonce test is what? Novelty, utility, non-obviousness, and it must not be a statutory subject matter. Means not a legal subject matter falling in section 3 of the Patent Act 1970. So all novelty means what? No prior claiming, no prior publication, no prior public use. So if somebody has earlier claimed in any patent application, it becomes not patentable because it is in the public domain. Prior publication by in the way of journal, conference proceedings, newspapers, now even the social media, because students normally have such kind of excitement after innovating something. It's like they can post something on their social media. Like today I have observed this in my lab. This is a great finding. This is a good product I have prepared today. So this will become in the public domain, and this will lead to the qualification of the patent application. So it is very important that until you reach the patent office, means your application reaches the patent office through online mode or through paper filing mode, it must not be in the public domain. One important part is the wrongful obtainment. Suppose today you have discussed it with somebody, and you have discussed in good faith, but somebody might have stolen your idea just after the discussion. So, and you are unaware of that. So you can claim to the patent office that this patent is taken by another person by wrongful obtainment. So I have not discussed, but I have just discussed in good faith, but somebody has taken my idea, stolen my idea. But it's very difficult to prove that that person is stolen your idea, because if you have discussed, then it is very difficult to prove. If in case you have not discussed, and somebody has taken your idea from somewhere, like by stealing or something, then you can prove, but it's really difficult to prove to the patent office like this is wrongfully obtained. So it is very better that not to disclose your idea to anybody, and also unless until you file your patent application, keep your idea secret. So it must not be in any public domain. And another is prior public use. It must not be in public use. This is a very subjective term. I just want to tell you one thing. Suppose a civil engineering student has prepared a concrete which is very strong and which can withstand lot of loads. Loads of trucks, loads of heavy loaded trucks can cross it, and there will not be any vibrations, because that concrete that is used to make some tiles or the pavements makes the pavement or the roads very strong. So how to check that? How you can claim that my cement is very strong, the tiles, that pavements made using that cement is very strong. So how to do that is like we can do a very restricted trial. Means like a particular small area we can choose in which we can like display our payments, we can like make a small road, a small pathway using that pavement, and allow certain group of trial people who are in confidence with you. So you can get signed a memorandum of understanding with them, or some consent letter with them, some kind of agreement between two of them. You is like those subjects will never reveal your innovation to anybody. Okay. So in that way, you get it signed, and then those documents must be with you. Then allow those persons to walk on those pavements, or some truck drivers to like move with their trucks on those pavements. And then if you have done such trials and documented it using the small group of subjects in a small area, restricted, confidential, bounded with an agreement, then this is not in public domain. So in that case, actually this public use was a part of your experiment, was a part of your trial to check the validity of your product. So in that case, it is allowed. It doesn't come under the like loss of novelty or novelty destroyment. So in that case, prior public use is allowed, but it is very important to understand like how we can conduct this. Otherwise, if it is open for public, normal public are like crossing over it, making opinion or testing the quality, or even somebody is taking up the one tile, and going to their own lab, testing the quality of the material, trying to find out what it is, how it is working, then obviously it is the public domain, and you cannot claim for the patent of such product. So in that case, prior public use becomes a cause of rejection of your patent application. So this is very important. There are many cases which have happened where the applicant failed to prove this, and that's why their patent got rejected. So novelty must be such that it must not be earlier in the public domain before filing the patent application. Inventive step, whenever we talk about inventive, how much inventive we have? In my opinion, I'm very inventive because I have added some innovative feature in the already existing innovation, and then I'm making it more technically advanced. Point is that whether patent office will consider, or is it really technically advanced, that criteria is very subjective in many cases. But how to rescue that, means how to pass it smoothly, is like you should have a big gap between the already existing and your product. If you are making very similar to what is already existing, definitely there would be difficulty in the of the patent controller also to give you the grant of the patent, because they will not be sure whether you have really added the technical advancement or it is just a small replica of already existing innovation. So that's why it is suppose this is a small cartoon, but it gives a very good highlight about it. The like patent agent or the attorney of the applicant says that no, he is innovative. Another says that no, I don't think so. Patent controller, I have to decide. So how to keep it is like add more and more technical advancements. Don't be just obvious. So in that way, it was means like you don't need to fight much for patent. You can get it easily if you have added more innovative features. Nowadays, inventions are rare. We are doing mostly innovations where we are adding some technical features over already existing ones and making it more better, more consumer compliant, somewhere more economical. Anywhere we are making it better. But how much better? It is important to be much better as compared to just more better. So none of this is inventive. Now, students, people ask me, means we have to be complex? We have to become complicated to get a patent granted? No, definitely not. A very simple innovation also can be obtained, such as this is a very simple example of coffee collar. This is a very simple innovation where like it could be stacked, it could be stored in a very small space by stacking. Once needed to be used, it could be just like pressed a little, and this will take the shape of a collar, and we can hold any hot coffee easily in our hands. So this is a very simple innovation, but patent has been granted with this. So it doesn't have to be very complex. What is important is like usefulness. How much useful we are making our product, and we don't need to make it so complicated, But definitely, if we are choosing a complicated product and trying to be better than that, we have to be more and more complicated, definitely, because technically advancement means better, better, more better than already existing. So always we have to consider that. So how to know that what is existing already? We have to do a very extensive patent search. Patent search can be done through free sites also or through the paid patent search sites. I recommend PATS here, PATSEER. That is the most easily usable where we can get the synonyms. And those synonyms can be used by using the Boolean operators like and or. And we can get the relevant number of searches which are very close to our innovations and how we can be better, or if we are similar to the already existing prior art, why to carry out the innovations? We have to postpone that, and definitely we shouldn't go for patent filing. We should postpone it till we will become more and more innovative. That is a good suggestion for all the innovators, that carry out a very extensive patent search that will give you almost half surety that your patent will be granted on in later courses. What is not an invention? So now we have understood three criteria, that is novelty, usefulness, and industrial applicability. Industrial applicability, the third criteria that we had just discussed, is anything we make must be reproducible. Means once made, and what quality we are achieving by just making it for one time. Many times we are making, suppose every time we are getting the same quality. So if we are going for a batch manufacturing, there should be very less to batch variability, irrespective of who is preparing it, where it is going to be prepared, what instrument is used, what environmental conditions are used. But our product will always be robust, rugged, and reliable in quality. Then only we can claim that all our batches are same. All consumers are getting the same product. Like suppose we go to the Domino's pizza, everywhere in the world, it will have the same taste. Why? Because they have maintained a certain quality. The same is applicable with the product that we are preparing. So if we have done some lab testing and we are very sure that yes, it could be made or used in industry, that is a word, made or used in industry, then it is said to be industrially applicable. So always patent office checks this. Your reproducibility data must be along with your patent application, that you have done trials and every time you got the same results. So it could be scaled up at a bigger scale and could be manufactured also. So I think the three steps we have understood. The fourth one, that is statutory subject matter, means anything which is not coming under section 3. So section 3 of the Patent Act says that what are not an invention. So an invention which is a frivolous or which claims anything obviously contrary to well-established natural laws are not patentable. So suppose something is in the natural law and we are intervening in the natural process. One patent had been filed in 1986, that was the dimple drill. So those people who were unhappy because they were not born with dimples were can use this apparatus to drill the dimple that they always wanted. So this was a kind of cosmetic preparation that was actually giving dimples without the people born with dimples. So patent office considered it as not patentable. So this was a non-patentable inventions as declared by patent office because this was contrary to the natural laws. Anything which is considered to be frivolous, or it's the second 3B says that anything which is primary or commercial exploitation would be contrary to public order or morality, or which causes serious prejudice to human, animal, or plant life. So what is the major purpose of getting a patent? To make something useful for the society at an affordable cost. And it could be should be made in such quantity that all can, it is like it could be affordable, it could be available to a large mass. Patent office says that. This is the criteria that every patentee after getting the patent should fulfill. So suppose today I have got a patent and I have to prepare the product. I have to ensure that within 3 years, I'm making so much amount of product that I'm making it available to the general public at an affordable cost. If I'm not doing so, patent office will say me to give the license to somebody else. Compulsory license comes here. Why I'm discussing here? Because patent office always consider that what you prepare, it must be for the large mass at an affordable cost. If you are fulfilling these criteria within 3 years of getting the grant of patent, you can continue. Otherwise, patent office will say, give this patent to a company, anyone who can prepare and prepare in such amount that people will get it and also at an affordable cost. So compulsorily, we have to give our patent to somebody else. That is compulsory license. That has to be given. So one criteria is usefulness for the large mass. So related to that, this section says that anything which is not useful or which is causing serious prejudice to human, animal or plant life or health or to the environment anyhow will not get a patent, such as gambling machines, device for housebreaking, unlocking cell phone. Sometimes it's a very useful thing, I think, because somewhere we like lock the phone and forget the password. So somewhere we think, is there any invention which can unlock my phone? But this is, even if it is very innovative, very technically advanced, patent cannot be granted. Anything which is like any gene therapy which is creating something which is hazardous, or any biological weapon, anything which is not like for the human, even for the human, for the evil purpose, that is never to be granted. Even one thing is like one example, one case study I wish to state here. Normally, for alcoholics, the police roams with an like detector. They're like, whenever they exhale, they collect some exhalations and they test it for the alcohol content. So somebody has prepared some kind of chewing gum, like whenever they are being chewed, that exhalation will not have that because they will neutralizing the smell of alcohol. So that chewing gum was actually preventing to be caught. So that was done using lot of innovations, means like that was not for exactly for traffic purpose. That was whenever somebody was taking alcohol, but even then the smell was not being detected. So this was helping. These are the two case studies that I'm discussing with you. But this was not given a patent to the applicant because they said that this could be misutilized. So any warfare material, anything are not getting the patent. Here I wish to discuss one thing. If many of the innovations are like drone innovations, which are very common nowadays, but those drone innovations must be for a useful purpose that we can understand. But such kind of innovations are normally not being published unless until they are being prepared, they are in knowledge of the government, they are in collaboration with some of the government bodies, or unless until they are already being prepared and available. Because if this is being published like a normal patent application and somebody has gone through and that person is not of the good like mindset, they can prepare the same and can misutilize that. Any biological weapon, any warfare material, that normally the patent has many restrictions. Section 3C says that whenever we discover a scientific principle, like Einstein, Archimedes, who have really marvelous scientists who have discovered something, um, but that discovery is never patentable. So there is a very clear margin about discovery and innovation. So discovery is what that is already existing in the world, in the universe. We have just explored it. Innovation means that had never existed in the world and we have made for the first time. So suppose if we have discovered a new gene, so that is it patentable? Yeah, definitely the process will be patentable because that process was not in the public domain. We have innovated a new process of genetic engineering through which we have discovered a gene. That process will be patented, but that gene is not because gene was already there. I have just discovered it. My process is novel because earlier that process was never applied. That's why this gene was never discovered in the past. The same I had discovered using my novel process, so I will go for a process patent. I will never go for a product patent. So why? Because gene was existing. Suppose I have discovered a star. There, I have discovered a new star using my binocular. So that binocular will be a product for this, not the star. So binocular, why? Because this is an innovative product who helped me to discover the star. The same way, any process uh, by which we can apply to discover something new, that process become patentable. Now, one landmark case I wish to discuss about it, that is Funk Brothers Seed versus Carlo Inoculants Company. This are already the Supreme Court decisions. Whenever some of the law students can visit the Supreme Court website, they can find many patent decisions that are very useful. I'm discussing some of them here. So what has been done? Uh, just a minute. Just a minute. Yes. मैं यही हूँ कॉरिडोर के पास, कुछ काम है? ठीक है, आप लेकर के आ जाइए एमफार्म की ट्यूटोरियल रूम में. So I think this is audible.
There is an echo coming in, Dr. Prachi. I think both your devices are. You have to mute one.
Any reverberation from my side?
Dr. Prachi, you have to mute one of the devices.
Yes, now it is okay.
Is it okay?
No.
Some reverberation.
Prachi, the device that you are presenting from, can you, or the other one of them you will have to mute. Yeah, I think this is fine. Thank you. Please continue.
Is it okay? Is it fine now?
Yes, it's fine now. Please continue.
Is it audible? Okay.
Thank you.
So I'm continuing with this. So a landmark case that had been discussed was the Funk Brothers Seed Company versus Carlo Inoculants, where what has happened, the Funk Brothers Seed Company, what they did, they prepared a composite mixture of 6 strains of bacteria. Package to be used to inoculate. Just a minute. So it was a composite mixture of 6 strains of bacteria packaged to be used to inoculate the leguminous plants. So what they did, actually, they have taken 6 strains of bacteria, packed them together. The 6 strains were highly powerful, and those were really compatible with each other, and that's why that was really helping the leguminous plants to grow. So some bacteria are nitrogen fixation bacteria, so in the soil. So they have made such a packaged in a sachet and they supplied. So that was really good product that normally farmers used to buy it, just add in the soil like a fertilizer, and they observed a very good growth of the leguminous plants. But Supreme Court said that this mixture is containing the materials which are already in the public domain. I'm really sorry for just 1 second. Hello. Farm technology ki tutorial. So Supreme Court said that the mixture is just containing admixture of 6 strain of bacteria which are already in the public domain, which are already existing in the nature. So it was said that
Ma'am, sorry to interrupt, but your voice is not audible.
Okay, is it audible now?
Yes, yes. Again, we are not able to hear your voice.
Is it audible, sir?
Yeah, it is audible, but I think there are two devices connected, so you need to switch off one device. Yeah, so I think we are not.
Is it audible, sir?
It is audible, but two devices are
Sir, I'm connecting with just one device. Why it is happening?
maybe your cell phone is also connected. Could you please
Prachi ji,
check?
not only will you have to mute,
Is it
you
okay?
also have to.
Is it
आपको
okay now?
एक का, Dr. Prachi, you will have to reduce the volume of the other device, one device to complete minimum. वॉल्यूम मिनिमम करना पड़ेगा और उसको म्यूट भी करना पड़ेगा, स्पीकर भी ऑफ करना पड़ेगा और
Two voices from your side, so I'm not able to hear.
Okay, I'm going to call you.
Is it audible? Is it fine
Yeah,
now?
now
Yes,
it
yes.
is fine. Now it is fine.
Then I will continue. Archimedes' principle or any superconductor phenomena are not patent. So, suppose if we say that property of certain material extend the mechanical shock, so that property is not patented. But suppose if we are making a railway sleeper coach using that material, that railway sleeper coach is a product. So that is patented. So any property is totally not patented, but using that property, if we are making our two voices are coming, or is
Yeah,
it perfectly fine?
yeah,
it
we are
okay?
able. Yeah, we are able to listen to your voice. Yes.
Is it fine? Can I continue?
Yes, yes. Please continue.
So railway sleeper coach is a product. So that become patented. So suppose if we are generating a mathematical formula, and for how generated data, so the formula, any kind of such property is not patentable, but new generator that is using that mathematical formula. Again, one thing, if you are doing a scheme or how to sell a generator, that is not patented. But the use of the generator on a bicycle, method of manufacturing the generator, these are all patented. So, a new generator or the use of generator on a bicycle, these are product patents. method of manufacturing the generator is a process patent that is again the patentable. Now comes the section 3. Section 3D is very important for especially for the patents. Why? Because those who have prepared things like solidity enhanced products or reduce the size of the material for enhancing the availability of the product or use the mixture of isomers or any combination, any complex, patent is considered it as a not patentable inventions. Why it is happening? Because earlier, before 2005, this section was not there, and patent was not considered so important for innovations. Why it has happened? Because earlier, whenever we had applied for salt tester, which are just the small changes in the product. Like suppose we talk about chlorpheniramine, that's anti-allergic, and another salt is malleate, the ester salt, that has almost the same recipe. But people used to make the product using chlorpheniramine malleate, enter the market smoothly. So what happened? Those who already prepared a product using chlorpheniramine will not get a full monopoly right. So that's why this section has been introduced, so that some research and development must be introduced, and not people will just use like small versions or small makers or small changed for innovation and getting the patent. So, this is just to give a push to research and development. For getting a patent, everybody has to do research. There's something very novel. Not we can just apply for salt, ester ether salt of certain substance. If we are applying the patent office has, we have to convince patent office that that metabolite, that salt, that ester is highly potent in terms of efficacy, in terms of its bio. So suppose if we are to know that you aspirin is like used in heart ailment, but suppose if we are preparing a new use of aspirin, claiming for that, patent office will not grant the patent. We have to say that new use is really beneficial, has never been urged in the past, and we are using at least one new reactant. This is not just like a small change ester or ethanol or reducing the size or just solubility in products, but actually this is some reactant. We are synthesizing something new, which is not just the polymer isomer mixture of isomers like this. So patent office considers all such salt ester as the same substances until they differ significantly in properties with regard to it. So that is the section. Famous patent cases, is especially Roche versus Cipla. So there is a crystalline form of ganciclovir. So Chennai Patent Office rejects the patent claims in 2015, saying that ganciclovir and valganciclovir. Ganciclovir was just like some kind of crystalline form of the known drug ganciclovir, and that doesn't have efficacy.
Yeah, Dr. Prachi is going to rejoin because of her because some problems, with respect to like screen sharing and all that. And please be.
Is it audible? Is it audible now?
Yes, yes.
Yes, yes, yes.
Okay, fine. Is it clearly visible?
Yes, we can see the screen.
Yes, ma'am.
So I think this will go on. So this case, so valganciclovir was nothing but a small crystalline form of the known drug ganciclovir. So that's why patent was not given. Another case, Hoffman-Roch versus Cipla, where Roch erlotinib. Erlotinib was nothing but a polymorph of gefitinib, and this was used for lung cancer or pancreatic cancer. It was opposed by Cipla. So what was the problem is like it was just a polymorph of already known drug gefitinib. So Cipla opposed it. Why? Because if Roche gets the patent of erlotinib, there would be similar drugs in the market, and so the market capture of Cipla will go down. So High Court allowed the Roche patent. Cipla filed SLP in court. So when High Court considered that erlotinib is not just the same as gefitinib, they allowed the Roche patent. But to oppose that, Cipla filed SLP in court. After 9 years of court case, settlement between two pharma giants in 2017 has happened. So what has happened? Court, what they did, they allowed Roche patent and also said that Cipla is not infringing. So suppose if Roche erlotinib comes in market, the Cipla has also the same product. So there was actually a case of infringement where Cipla was infringing the Roche patent. But court decision was a little bit kind of towards both the sides, where court said that Roche is also correct. Roche erlotinib is not just like similar as the gefitinib. It has novelty, and also said that Cipla is not infringing. So that was a decision that was a little bit remarkable case where both of the company were entering in the market simultaneously along with a fight among each other. But after 9 years of cases, settlement done between both of them, together settlement, mutual settlements, and both are now in the market together, Roche and Cipla both. Third case is USA's Novartis versus Union of India. What has happened? I just mentioned that before 2005, Section 3D was not functional in India. So Novartis has filed an application for beta crystalline form of imatinib mesylate, that was Gleevec. So earlier, imatinib mesylate was there in market, but they have filed the beta crystalline form. So before 2005, it was accepted in India. But once earlier, the system was that exclusive marketing rights, as well as there was a kind of system where, just a minute. So what happened is like earlier, before 2005, there was a mailbox provision. So the application was in the mailbox. In 2005, when Section 3D came, the patent application of Novartis opened. And now Indian Patent Office rejected the Novartis application because after 2005, Section 3D was applied. So Novartis opposed it. Why I shouldn't get the patent in India? So because I have filed it earlier and my product is a crystalline form. But when I filed, there was not Section 3D. So, but Indian Patent Office rejected it. Indian Patent Office was against that because now Section 3D was applied. So 7 years long litigation was fought by Novartis for this drug because this was a blockbuster for Novartis. The Supreme Court later on upheld the Indian Patent Office rejection of the patent application based on Section 3D. So Indian Patent Office was totally adamant. Novartis went to the Supreme Court of India. There also, it was decided that no, beta crystalline form of imatinib mesylate is the same as imatinib mesylate. as per section 3D, and it was rejected. So, but it is not like that any polymorph, any salt form is never getting a patent. They can get, but when they can get, whenever they have a very strong potency, they have a very strong bioavailability, and they are really useful. And in that case, it could be done. So, next, section 3, it is said that whenever substance is just a mere admixture, it is not patentable. So if we are combining just paracetamol and ibuprofen and giving it as an antipyretic as well as an analgesic drug, it is considered to be not patentable. Also, if we are making ORS, which is a very useful product, but containing glucose, sodium chloride, sodium bicarbonate that are functioning independently. Glucose has their own function, sodium chloride. What we did, we have just combined. So any aggregation, any combination is not patentable unless until they are synergistic. Synergistic means if we are combining paracetamol and ibuprofen, and because of that combination, the dose of each of one is getting reduced. So instead of giving 500 mg paracetamol, if we are giving just 300 mg or ibuprofen, where the dose is reduced because of combining them together, it becomes patentable. So simple combinations are not, but whenever combinations are giving a beneficial value, it becomes patentable. Section 3F again says just if we can assemble something together, it becomes not patentable. But if the assembly components are interacting with each other, it becomes patentable. Suppose umbrella and torch, or umbrella or fan, these are just combinations which are not patentable. But whenever there is a certain kind of correlation, suppose a sensor lights the torch when umbrella is opened in rains or dark, then there is a proper interaction, and this becomes a unit invention. So unit invention means all the components are working together. So this interaction leads to a patentable invention. Again comes section 3H is like any method of agriculture or horticultures are not patentable. So one example is NV Philip fabricant application, where method of producing new form of plant is not patentable. Because if that method become patentable, the cost of that plant will go high, and this will be a hazard to farmers. Again, Virginia Carolina chemical crops application. Here they were producing the soil fertile with nematodes by treatment with chemicals. So if we are making some soil fertile, it is a method of agriculture, and this will increase the cost. So simply thinking, this will create harm to farmers, which are cannot afford such kind of fertilizers if they are getting patented and the cost become very high. But this another application, that is Joseph's application, you can find all these cases are in the like sites. Process of production of edible mushrooms are patentable as end product is neither animal nor plant. Mushrooms are basically fungus. So animal not plants, so mushrooms become a product. And also that is not just like that, there are a lot of human interventions in preparing a very clean, very safe mushroom, edible mushrooms. So this product is patentable. So only thing is that definitely if there are a lot of human interventions to surpass these criteria, definitely there are silver linings in each of them. Simply doesn't think that if we are in section 3, our inventions are simply not patentable. They can be, but yeah, if there are a lot of human interventions. Section 3, this says that any process for medical, surgical, curative, prophylactic, diagnosis, therapeutic, or other treatments are not patentable. So if treatment become patentable, treatment will become high, and it will become unaffordable to the general public. So suppose removal of cancer tumor, painless, painful or normal ones, removal of dental plaques and caries, if they are painless and good ones, definitely that is a process, but this process, even if it is novel and good, useful, these are not patentable. But surgical devices, these are patentable. The most important one, there is a bunny syringe US patent number this, where normally children are very afraid of getting vaccinated, because whenever syringe or needle approaches them, it become a kind of phobia for them. But this applicant has invented a bunny syringe where there is a bunny attached on the tip of the syringe, And whenever this was approaching a child, this was thinking that a toy is coming to them, biting them a little and again going back. So child was actually enjoying and laughing whenever they were being vaccinated. So this was a very useful innovation, got a patent, and any therapeutic or diagnostic apparatus, even they are they can not excluded patentability. So apparatus, instrument, devices can get the patent. Definitely, devices are very good products. Again, section 3J, plant or animals. These are wholly or in part, these are not patentable. But if there are a lot of human interventions because of genetic recombination, this become patentable. For example, the ball guard to BT cotton of Monsanto Bayer. They have prepared genetically modified cotton seeds which are really good innovations because they are not just discovery, but there are a lot of lab works, lab studies done in the genetic recombination. And that's why, but after a lot of fight, there was also that section 3J was being applied, but they fought a lot and relief to biotech sector was given by Supreme Court so that DNA, RNA, gene editing type of innovations must be promoted. So there was a boom in the biotechnology sector after 8th January 2019, whenever Monsanto Bayer got the patent of genetically modified cotton seeds. So definitely these patents are very valuable, but we have to remember that there are a lot of human interventions must be involved. Then mathematical or business method or computer program or algorithms are not patentable. They are copyrightable material, softwares, written programs. But suppose if we make it applicable, suppose algorithms for applied can be applied for data compression in banks, telecom, or education sector, where the voice is being compressed to be effectively transmitted over 2G, 3G, or 4G. So this become a industrially applicable. Why? Because they are always working in the correct bandwidth. They have the same frequency always, and voice is being compressed properly to make it industrially applicable 2G, 3G, and 4G, um, network spectrum to be used in telecom sectors. Even algorithms, if they are being used in banks or education sector, it becomes patentable. So very important example, Google filed patent application for use of computer program to develop computing devices. Oracle filed a system and method for preparing compended blocks. So these have already received their patents because they have applied the softwares to prepare some hardware or some product, tangible product. So that's why they got their patent. Then section 3I, any literary, dramatic, artistic work, method of playing game, rules of cricket. These are very simple things. So these are copyrightable material, very good subjects for copywriting, but not for patent. They are not patentable. Presentation of information. If I present in a very novel way, definitely it is creative, and creative works are copyrightable. Topography of integrated circuits are not patentable, but they are protected under the separate act, that is Semiconductor Design Act, where semiconductors are very useful preparations, but nowadays in filing of semiconductor design are very less in India. That's why the cost of products are going high. Semiconductors are really being filed in very less numbers, but they are protected by a separate act. Section 3P, any traditional knowledge. If I'm using neem or turmeric, which are already known by our ancestors, and making a paste and giving to public, it becomes not patentable. But yes, if I'm preparing a nano vesicle, if I'm preparing a nano suspension of curcumin for better absorption, for better efficacy, and that will be my product is nano vesicle, nano suspension, not the curcumin. Curcumin just become a component. So in that case, my product will be patentable. So it is important that if you're using some traditional product, there should be a lot of human interventions. Then only we can make a patentable product. Section 4 says that inventions related to atomic energy can't be patentable. They are protected under a separate act of Atomic Energy Act 1962. So anything related to this is not patentable. So I hope that some questions I can definitely answer. I just want to talk about artificial intelligence. Artificial intelligence-based products are nowadays very popular, and AI is now becoming patentable. AI-based products. So I will definitely share this presentation with all of you. Here, if we are preparing AI-based products, these are now getting the patents. If any question are there, you can ask me. Claim drafting, definitely I can't cover it today, but in the next session, definitely possible, I will go for an elaborate claim drafting because this will take much time and this should be together in a single lecture. So if any question, please ask. Questions are really welcomed by the innovators. And thank you so much. Please ask the questions if any.
Dr. Prachi, I thank you very much for giving this nice talk. We got to know about what are the things that can be patentable, what are the inventions that cannot be patentable. With so many examples, this is a very good session. Thank you for giving this. I mean, we would certainly look forward for continuation of this kind of informative, sessions. Thank you very much. And if there are any questions, I think even if it is not asked right now, if there is any questions, we are going to send it to your email ID and you can reply to that.
Sure, sir. I will be happy to answer them.
If there are any questions, please, you can ask them, like, anyone who has any questions.
And I'm really sorry for some interruptions.
Yeah, sure, it's okay. Thank you. Thank you for that. So if there are no further questions, again, I thank you, Dr. Prachi, for actually giving this such a nice talk. Thank you very much.
Thank you very much.